Welcome, everybody, to our conversation on juvenile court custody orders. This is a topic that kind of crosses over between family law and dependency law. And I am Judge Geraldine Borak. I sit in Sacramento Superior Court. My current assignment is juvenile dependency. I've been there going on 5 years. I also sat in family court for 5 years. And so this is a topic that really is very near and dear to my heart. What about you?
Hi, I'm Shauna Schwartz, and I am a judge in Santa Clara County, California. I've been in dependency about, I think, 10 or 11 years now, and I did spend 2 years in family court also. So, Judge Borak, as much time as I have spent in dependency court, I still find the juvenile court custody orders at the end of the process to be challenging.
Well, let's take some time and we'll talk about the various steps of what you have to go through in your mind and what they're for. And I think that if we go through that process, it'll be easier for you. For example, let's start out with when you make them. When do you know that you need to have a juvenile court custody order? Now, I know that these are always, when I first started in dependency, everybody called them exit orders. Right. And we're trying to make everybody change that now and call them juvenile court final custody orders. That's what it says on the form. And so when do we do them? We do them when we're terminating, when we've had jurisdiction and we're terminating jurisdiction. So one time might be when we are turning the child over to the former non-custodial parent.
So from disposition, where you've removed from one parent, placed with the previously non-custodial parent, and now there's no reason to keep the case open, you terminate the court's jurisdiction.
Right.
Okay.
Right. 361.2, Welfare and Institution Code, and you have lots of choices as to what you do with this formerly non-custodial parent who wants custody. And one of them is you give him or her the kid, and and then you terminate jurisdiction. And at that point in time, then the non-custodial parent would need one of these orders.
Okay.
And then, of course, the obvious is when you're at the end of the case, reunification has happened, and you're terminating jurisdiction. So, but we have parents that are in different situations. So, is there ever a situation when you don't do one of these custody orders when you have two parents?
When I have two parents? Well, if they're an intact couple and they're married and they're living in the same home. So generally, we don't do them then.
Yeah, I don't either.
Okay. Clearly not in a situation where you've placed with a non-parent. So no sort of guardianship. You wouldn't do this in a guardianship or an adoption. This is, the custody order is as between the two parents.
Agree.
Okay. What about unmarried parents who are living together? Do you do them then?
Well, yes. If they're unmarried and living together, I do a very simple one. I do, joint. I can't designate a parenting time because just like our own intact families, if we have one, you're in and out. And, but I do tell the family court, and we'll talk a little bit more later about, what do you want to tell the family court in these orders? I do tell the family court that these are two parents who are living together so that they know that when the parents separate something and the parents go to them and say, I need a parenting plan, they'll realize that when they left my court, they weren't separated.
Okay. So in these orders, we're looking at the choices are the legal custody, sole or joint, physical custody, sole or joint. And then I believe the form also talks about primary residence with.
Correct.
That you have to fill in.
Right. And visitation. What kinds of visitation?
Okay.
Right.
Okay.
So let's talk about visitation for a little bit. I mean, we have no visitation, we have supervised visitation, and the form that gets attached to, what is it, the JV 250 now?
205.
205. Got my numbers reversed. Has very detailed, weekends, whatever. I don't usually have a plan that is that detailed. Do you?
It depends on how well the parents get along, the age of the child. We generally use the JV 205, But I note that it doesn't include things like Mother's Day, Father's Day, Christmas, Hanukkah, Thanksgiving. And so very often we'll refer the family to our dependency mediation to come up with a more detailed plan for some families. Some families feel like they can work it out and they don't want something that detailed. But if a family has come before us, for example, if it came to us as a family court case to start with, and we know there's a high level of conflict and a lack of ability of the parents to work together, we're going to want much more detail in the juvenile court final custody order to sort of reduce the opportunity or the chance for them to come back and want a change anytime soon. But we do use the JV 205 fairly frequently.
And I found that the most successful way of doing it is to have the parents and their attorneys meet and confer. And so that's the way I usually order it. And they usually come back with a relatively decent plan that's relatively detailed, but certainly not what the family courts in my county would like to have.
Right. And we actually have a form that I've seen. It's an attachment that lists all of the, the holidays and is set up so that they can check boxes, odd year, even year, who gets what. And we've found that if we can't get a mediation slot anytime soon, and keep in mind, people are generally pretty anxious when we're ready to dismiss a case to get out the door.
Oh, in your county
Imagine,
too?
Right?
Imagine that.
Sure. But if we can't get a mediation slot soon enough, having the parents sit down with their attorneys to check the boxes and to come up with some agreements has been successful.
That's an excellent suggestion. What I'm going to do is to look at all of the forms that they use with the family law forms and maybe even give them to my attorneys now as a template. That's an excellent suggestion.
Okay.
There are other kinds of visitation orders too, and those are the less detailed ones when you have one parent who really has not been very successful in reunification. You're either ordering no visitation for that parent or supervised visitation for that parent. And these forms are not confidential. Right?
Right.
They, by statute, they are supposed to, or we are encouraged to use them to open up a family law case if there isn't one pre-existing.
Right.
And if there is a pre-existing case, then they go into the public part of that family law case, right?
They do.
And so I want to tell that judge why it is that I'm not ordering any visitation for this person. And so that's where I struggle in terms of how detailed I get in terms of where that parent is, what they've done. And I think the more direct and the simpler, I mean, we don't really have to tell them the whole story, do we? What do you think?
No, I agree. And there's a balance between the confidentiality, which we guard zealously in dependency court, and the openness of family court. But we do want the family court judge to understand why we're ordering no visitation or why we're ordering supervised visitation only. The other challenge is the form doesn't really include, a nice box for us to write in what we want the judge to know. But there is the case Chantal S., which I think is from 1996, which talks about the fact that the juvenile court can include conditions for a parent before they, for example, get unsupervised visitation as opposed to supervised. And certainly in the context of making an order like that, saying things like, the parent has to demonstrate a year of sobriety before getting unsupervised. So we do have the ability to add conditions, and that's been found to pass muster which I believe the family court cannot necessarily do in the same way that the juvenile court can. That certainly can tip off the family court judge what the issues were. I struggle with writing in a form that I know is open to the public. Dad cannot have visits until he, finishes his sexual abuse class, because you're tipping off. You're letting everybody know what happened to this child. But I think there's a balance there. Do you put in there, because this was a 300D case, father needs to complete counseling before unsupervised, so that the judge has to look it up. You don't want, that judge is just as busy as we are. So do we want that person to have to read between the lines, or do we make it clear?
Right, and if we either use the code number or the word abuse, we're still tipping off to the same thing. I would err on the side of more information for the family judge, because the whole purpose or purposes of these orders is to help the family. And we all know that in family court, they don't have attorneys. In my county, it's upwards of 70% are self-represented. And to make them have to explain to the judge where they were and what the circumstances were, I think the judge appreciates it coming from us. I think they appreciate it coming from us. I think when they look at the piece of paper that they get afterwards from us, they feel that they've got something that, a rock, an anchor, that they can use too. Are there other reasons that you can think of that that this kind of specificity in these orders would help?
Absolutely. Every time I go to a bench meeting and see a colleague who has just gotten one of my cases and they are not happy, I think it becomes much more clear why we should give them as much information as possible so that they can do a good job. But it's not just what we give them in this order that's important. I mean, the family court judge has complete access to the juvenile court files, and I believe that's the Welfare and Institutions Code 827 that says the family court judge can read it all. Now, I don't think they always want to go through 6 volumes, and I think it can be challenging for the judge to get all of those volumes and to come to some understanding of why we did what we did, which is why I think writing it in our orders is probably a better idea.
Right, and the parents, obviously, even if they haven't saved all of their own papers, they have been provided whatever is in the juvenile court file if they've participated in the juvenile court proceeding. We have some parents that don't participate in our proceedings,
right,
and but they have complete access to that file too as a parent.
Okay.
Because it does say on our JV 200 form that these are final custody orders, and of course that is a buzzword in family law for what the judge, the standard for modification. So let's talk about modification.
Okay.
You want to start?
So, well, and this is a good segue because in our county we created a local rule. So if a family seeks to modify the order within 1 year, that case is coming back to me, but I sit as a family court judge, which gives me motivation to do an ironclad, nice, specific, enforceable custody order, so that there's less of a reason for them to come back and seek clarification or changes. But it does, any modifications happen generally it's a family court issue. As I said, in our county, if it comes back to me, I'm a family court judge, not a dependency judge. I'm not appointing attorneys. The only parties are the parents. And actually, I don't know in light of Elkins if the kid is a party now, the child is a party?
Child's not a party, but if the child is over 14, I believe, and wants to address the court, then you have to hear from the child.
Okay. So in terms of modifying generally, though, once that family court file is opened, we issue our very specific, very detailed juvenile court final custody court exit order. So much easier to say. Once we issue that juvenile court final custody order, it is lodged in the already open family court file, or if there's not one, it creates a new family court file. And then the matter goes to family court. So all modifications are heard there, which is why it's so critical that the receiving judge has a really good sense of what we did and why we did it.
Well, kudos for you for extending your job for 1 year for these families. I mean, it is a demonstration of your courts caring about, what happens to kids. And I don't think I'd be able to convince my judges to do that. No. How long have you been doing that?
We've been doing it for about 3 years now, and it really serves as a bar for people to come back and make changes when they know they're coming back to the same judge.
So do you hold them to the standard, and that is, it's that 2-phase standard for modification of final orders, going back to Burgess in family law, and first there has to be proven by a preponderance of the evidence that there's a substantial change of circumstances, and only if they can get over that hurdle do you look at the best interest of the child in terms of whether or not the modification would be in the best interest of the child. So do you go through that process when you modify?
Well, I assume I should.
Because you follow the law,
but
right?
But in reality, in the 3 years I've done this, I've only had 3 of them come back.
Really?
Because often what used to happen is families would leave dependency and not even go home, run straight to the family court to change the orders. And, it was very challenging for our family court, which is why we made this local rule and said, hey, how can we work on this better? Why doesn't it go back to the judge who actually knows the family? The family, and when they are leaving, I tell them, if you seek to change this, it's coming back to me. So that they understand they're going to get a judge who knows the history. They're not getting another bite at the apple. So we've had very few actually come back. And when they have, one of them it was pretty easy because there was no substantial change of circumstances. A second one, both parents appeared willing to talk about it and make some changes, and so I sent them to family court mediation to see if they could come up with something. Because one of the things that happens is, when they leave, making an order that lasts forever is just
impossible.
Right. And so there are going to be changes. The child is now in preschool, and that order that you made before, kindergarten, and that order you made before doesn't work because the child's in school and can't be visiting. So our process has really resulted in fewer attempts to modify the orders.
Well, one of the things that I try to do in order to make it so that they're not having to seek modification is to try to take the time at the end, kind of like we do in the very initial hearing, to explain the process to them. I take an equal amount of time when I'm saying goodbye to them to explain to them, what is this that I'm talking about? What is this order that I'm giving to them? What is the effect of it? And I always tell them that if they don't have a family law case, I always tell them this is going to pop open a file, because that's the way we do it in our county. I know it's not mandatory, but I would say that it is the best practice, especially when it's in your own county that the custodial parent lives. And I explained to them that if they had to open up their own file, it would cost them about $400. They like the fact that I've just saved them $400. And after I say that, they're paying much closer attention to everything that I say after that. Right. So I try to help them to understand what it is that this order is and keep it with your important documents, and this is the way to organize your life, and we'll work on it. And sometimes if they want to take longer and do a more detailed parenting plan once they know about them, I just put the hearing over for a couple of weeks and let them do that.
Right. And one of the things I find is they are so anxious to get out of there. They don't like even putting it over for a couple of weeks.
I know.
But again, I think it saves everybody time and anguish in the long run to have an order that is enforceable and understandable and detailed.
Right, and the ones that really are not getting along are usually the ones who like to have that extra time, because one or the other or both of them are very afraid of being thrown out there in the abyss without a net, right, so to speak.
Okay. So it seems like
let's get to the family court, okay? And they now have this case. We've said that they can get the file and look at it if they want to. Oh, one of the things I wanted to say was on the form there is an other box, and of course the other box is always, you know,
tiny,
teeny
right.
tiny, and you want to say 3 pages. And I usually just check that and say, see attached for further findings and orders.
Okay.
And then I do the same thing that you do on that and try to figure out how to explain to the family court without divulging too much confidential information what the situation is so that they would know what to look at after that. Do you have court commissioners or referees sitting in juvenile?
we do not.
See, in my county we do. So I'm wondering if your process would work in Sacramento. Right. I'm not sure how I get them to sit as family law judges, but we'll work on that since you told me that only 3 cases come back. Maybe that's a good selling feature.
Right, yeah. Well, you know, and I just want to make sure we're being clear, kind of the goals. I think we've talked about them, we've woven that in, but, you know, the idea of reducing the chance of conflict between the parties, so having an order that everybody understands. Enforceability. The unfortunate reality is that some people are going to need law enforcement to come out and enforce the order. And, you know, my concern has always been when you say every other weekend, you know, somebody's got to get a calendar out and go back from 2010 and figure out whose weekend it is. Our family court judges have told us they hate when we say as arranged by parents.
Oh, yes.
I understand why they would not like that. I also understand why there are some circumstances where it's a reasonable order to make.
When would that be?
Well, I think if you ask that of a family court judge, they would probably say never. But in my experience in juvenile, I think with the older children, the teens, where the parent has all along been willing to go at the teen's pace. You know, kids have their own schedules, and the parent, in trying to have a good relationship with the child, is willing to defer to the child's wishes about visitation, the child's schedule, and knowing the family, if I have confidence that they really can work this out because I've seen it demonstrated throughout the course of the dependency, then sometimes I do put as arranged by the parents. Again, I don't think our family court judges would necessarily like that, but I have assessed that it's very likely that this is going to result in a problem that will need to be addressed legally.
Right. So this would even be a shared parenting arrangement, but you would put in there as arranged by the parents given the advanced age of the child or something like that?
I've never done it where it's been a shared parenting. I've done it where, for example, it's usually the mother has sole legal and sole physical custody. The child is maybe getting to know the father or has a good relationship with the father. And the father has indicated a willingness to work with the child's schedule and to do what the child would like to do in terms of moving the relationship forward.
Well, even though I'm reticent to do that, I must confess, now that you've been so open about this, that I have done that on occasion too. And talking to you made me realize that sometimes you have a parent who lives out of state and they don't know when they're going to visit. What my attorneys like me to do is to make a minimum number per year.
Okay. I think a minimum is a great idea, but having law enforcement be able to look at the actual order and enforce it. And then, as we've talked about, though, the family court, if this is going to family court for any sort of modification, they have to understand what are we modifying, what's the reasoning behind the supervision of the visitation or no visitation or whatever it is. So I think that's why we care about doing this so nicely and cleanly. And, the less conflict between the parents, the better it is for the child or children.
Right. We don't want to see this family coming back to juvenile court because when they do, it's because something horrible has happened to a child, some danger, some really substantial risk. And I think that you're right, that enforceability, not only in terms of where they're supposed to be on Saturday or where they're supposed to be on Sunday, but also in terms of the supervised visitation and the possibility that somebody, gets out of incarceration, knocks on the door, says, I want to see my kid, they've got this order, you know, and that's what I tell them. I say, you've got an order, the order is enforceable. If you're afraid, call the police. You've got an order.
Yeah.
So I think that these are really important and that we can help children a lot with these.
No, I would agree with that. So, you know, one of the things that I see, and I want to make sure that this point comes across, I feel like the attorneys, the social workers have some idea that the default is joint legal custody.
Oh, yes.
And they come in, and we'll have a case that has involved IPV, interpersonal violence or domestic violence, and it comes in with a recommendation for joint legal custody. And I'm always the one questioning, why would we do joint legal custody when we have this, you know, power and control issue? And you know, the child's been with one parent, the other parent did not reunify. And so I think it's important to recognize that, you know, we don't have the presumption of parental fitness that exists in family court. Having gotten to know this family, the court's in a pretty good position to sometimes order sole legal custody in the right circumstances. But people think that they have to recommend joint legal.
Oh, I know. And let's not forget, of course, we don't have time to go into it now, but let's not forget the different kinds of paternity and that alleged fathers are not entitled to any kind of custody.
And in fact, let's be clear, I don't do these orders when I have an alleged father only. It's only if parentage has been established.
Right.
Okay, good. All right. But do you see a default toward joint legal custody in your court?
I used to, but now that I've served
You've hammered it in them now?
almost 5 years, we've done some education.
Okay, good. Well, apparently we need a little more on that. I see that all the time, including in cases with domestic violence, which it seems to not make sense.
I do, but the attorneys who appear regularly in my court know that all they have to do is kind of look up to the bench and just let me do the rest.
Okay.
Yes, I mean, I have parents who are incarcerated, parents who haven't talked to each other in a long time, one parent who has really had nothing to do with the child for 7 years, but may have signed the voluntary declaration of paternity, so he's a presumed dad, and they come in with a recommended joint custody order. It's pretty surprising sometimes.
So do you, in every single juvenile court final custody order that you grant, do you always include a factual basis somewhere on there so that the next reviewing court has some idea of why you did what you did?
Yes.
So in that other section you always put something?
I put something.
Like what?
Well, like what I just said. Father has been incarcerated, father is not, or mother, whatever. The parent hasn't had any contact with the child. The parent is an abusing parent and has not gone through proper treatment, or substance abusing parent who is still into addiction. The confidentiality goes to the child.
Right.
So I'm not reticent to put in lots of bad stuff about parents because I think that's what the family court needs to know.
Right.
And I don't believe that the confidentiality necessarily goes to them.
Okay.
You agree?
Oh, I absolutely agree.
Okay.
Right. I do agree with that. I'm just wondering, do you scratch out other and put factual basis? I'm just thinking out loud that I think that's a good practice, and I'm going to adopt that.
What I check the other box, and then I say, see attached for other findings and orders. Okay. And so I say, court finds that mother has a substance abuse problem and has not treated her substance abuse problem and still presents a substantial risk to the child, and therefore I am ordering agency supervised visitation when the father doesn't want the mother coming knocking at his door, crying, why won't you let me see? The kid's inside, crying, why won't you let me see? Agency supervised, and who pays for it. And so I just put it on attachment number, whatever that number is.
When do you do that? And do you tell them ahead of time what you're going to do?
I tell them at the time that I make my oral orders in court.
Okay.
And then that's what comes on the form when the form is done.
Okay, because we're handed the form on the bench and sign it right then. So you're saying you make your orders, then they prepare the form.
Well, I'm going to now crow a little bit too.
Good. Please do.
In Sacramento, the attorney for the parent who's got, the most custody, I guess it is, will email the form as an attachment to my clerk. Mm-hmm. And so we change it in the computer, and I sign it that day, and they walk out with it.
That's an interesting point, though. It's the parents' counsel who's doing that. In our county, the social worker fills out the form, and it's attached to the report so that when the report is distributed, people can see what the recommended order would be.
Yes.
Okay.
In our county, the recommendation goes into the report,
right,
but it is the parent's responsibility for doing the form.
And, I think that's a cultural issue with each county.
It is.
And I could see where that would be a hard practice to change. But it
Just
makes
like
sense.
having the case come back to you as a family law judge. That's a hard practice to change, too.
It is. Okay. Do you see any other outstanding issues?
I think we've covered them all.
Thank you so much for joining us in our conversation on juvenile court custody orders. We're hoping you picked up and learned a few points from this. First of all, how you actually make the orders and when the appropriate time is to make them. The second thing is the goal. What should be the goal of your orders that you're making? Third, what about the content? What should you include in your orders so that you actually reach those goals? Another issue is what do you do? What should you do so that you give the family court the most information possible so that they can make future orders? And then finally, modifying the orders. How do you modify the orders? What information is necessary so that the family court knows how to modify those orders appropriately?
So as you've seen from our conversation, these are all very challenging and very interesting questions. We hope we've provided you a guide to help you through this. Thank you.